The judgment delivered by the Court of Appeal on this matter is a vindication of the truth. It is a vindication of the rule of law. You see, I am one of those who took time to follow this matter keenly. And I have studied various processes filed in this matter, and the various decisions that the court has given relative to this matter. And it's been very clear to me right from the get-go that this case was nothing but a political witch hunt. It was nothing but a clear case of persecution against a leading member of the opposition who is deemed by the government as a stumbling block to their bad decisions in Parliament. They just cooked this case to intimidate him, to kick him out of Parliament, in the hope that there will be a by-election that they can influence with money, because according to them, fancies are cheap, as the third accused disclosed in the course of the proceedings. That is what this whole case was about. It was total wickedness, but total nonsense, because there was nothing in it. And as I read the majority decision on this matter, Samson, I was full of smiles. I was overjoyed to know that, look, we have men and women of conscience on the bench who are alive to their fidelity to the law, their fidelity to the state, and will not be misled by the whims and caprices of a despotic government who are only interested in harassing, intimidating, oppressing critical voices. That, for me, is what gives me joy. You see, it is important that, as lawyers, we help those watching who may be non-lawyers to appreciate what has happened. Because I'm saying, to many people, they think that Ato Jakpa, after making his case in court, has won a case. He has been declared winner in this matter. No, but far from that, that is not what has happened. For those who think that the court, after listening to Ato Jakpa and Jakpa and all the other accused persons, has decided to adjudge them winners or has acquitted them and discharged them. That is not what has happened. What has happened is that the Court of Appeal, having looked at the entire evidence that was adduced before the High Court trying this matter, and by evidence, I'm talking about the facts canvassed by the prosecution, and the testimony of all 6 witnesses of the state called by Godfrey Dame. The Court of Appeal is saying that on the basis of that evidence alone, they don't even have to hear the side of Ato Jakpa. They don't even have to hear the side of Jakpa. They are saying that it doesn't make sense for the states to prosecute a case of willfully causing financial loss to the state against Ato Jakpa and Jakpa.
And the education has to be reinforced.
Yes.
That when you are accused of a criminal offense, the law is that you are entitled to absolute and complete silence. You are not even supposed to say a word. You can be entitled to that. When you are put before the court, he that is accusing you has the burden to prove the accusation. So when they bring their people and they go through, and at the end of their testimonies, you take the view, or the court takes the view, that they have not made a prima facie case against you, you should not be called to also be heard, your side be heard. That's what he's saying.
Exactly.
It's not as if the Court of Appeal said, As for this case here, don't call these people.
Yeah.
It's the process.
In other words, the Court of Appeal is saying that they have not been able to adduce sufficient evidence to even warrant the accused persons to open their defense.
That's right.
The case is so frivolous, so bogus, so baseless and useless that the Court of Appeal is saying that the accused persons need not open their defense. I am not saying it. This is the Court of Appeal. And this is what we've been saying all along.
To say they are saying it's so bogus, it's so frivolous.
You see, I am even being charitable because Justice Akabuafo, my Lord Justice Akabuafo said, he doesn't find a logical, that is the word he used, a logical connection between the evidence and the finding that a prima facie case has been made against the accused person. Logical connection. I mean, how else can you explain this? I mean, it means that the case is so bogus. I don't recall the last time that the Attorney General took a criminal matter to court that the matter did not cross the threshold of submission of no case. I don't recall. I don't recall. This is what we've been saying all along.
Do you mean like a case that is being prosecuted by Dami himself?
Once it's a criminal matter.
No, but criminal matter, there's a number of them that the Attorney General prosecutes, and we win submission of no case many times, so it's not the case.
No, in recent time.
Very recent, yeah.
Well, like which ones?
We are in practice, so we can say that.
No, which ones?
No, I'm saying
I'm talking about a case like this where the Attorney General has taken a matter to court.
So qualify it.
No, like
a political prosecution,
exactly.
a political or public interest matter.
Public interest matter like this. Right? Because obviously this was a matter of considerable public interest.
That's right.
Where the Attorney General himself has gone to court. He is the one prosecuting the matter. And the Court of Appeal says, look, this matter is so bogus that it cannot even cross the submission of no case threshold. The accused persons need not open their defense. It means that on the basis of your own evidence, your case is bogus. That is what they have told them. And that is my first point. Number two, Senior Bobby has already, explained the ratio of the twofold decision taken by the court. But I think it's important to still emphasize for those who don't get it. This matter is so simple, and don't allow Godfred Dame to obfuscate the issues and confuse you. Godfred Dame went to court, obviously under the instructions of his boss, the president, and his government, that Ghana signed a contract to procure 200 ambulances. 30 of those ambulances have been supplied to us. Payment has been made to the tune of 2.37 million euros. Godfred Dame says that the ambulances are defective. They are mere vans. And so it means that Ghana has lost.
Experts have certified that.
That is what
that there are defects.
Yeah, that's what he says. And so it means that Ghana has lost 2.3 million euros. And the person who caused that financial loss, number one, is Ato Forsen. What did Ato Forsen do? Two things. He wrote two letters, one dated 7th August 2014, the other dated 2012, the other dated 2014, 7th August 2014 and 12th August 2014. And these were letters directing the central bank or requesting the central bank.
Because directing...
Exactly. Instructing, rather.
Was agreed, yes, that was
requesting the central bank to establish a letter of credit.
Okay.
For those ambulances. And the second one was a letter to the controller for certain monies to be released for the purposes of establishing that LC. So because of that, Ato Forsen has caused woefully...
for and on behalf of Setekwe.
No, Godfred Dame says he didn't have any authorization. You understand? Ato Forsen, without cause, due cause or authorization, just wrote letters requesting for the LCs to be established. Then the Court of Appeal is saying, look, all you are accusing this man of doing, that he wrote a letter to the central bank for the purpose of requesting them to establish an LC. How did that letter Ato Forsen wrote occasion a financial loss? Because the letter was to request for letters of credit to be established in favor of Big C. An LC is not payment. It is a guarantee of a promise of payment. Your own witnesses, 3 of them, Mr. Makwe, Ajimamenu, and the other one, all of them in the box admitted that a letter of credit, which is Ato Forson's crime, according to Godfred Dame, is not payment, but a promise or a guarantee of a promise of payment based on conditions. So the court says, what were those conditions? And who had the responsibility to check and ascertain whether those conditions have been met? Was it Ato Forson? No. Did Ato Forson take any other step beyond requesting them to establish the LC? No. Did Ato Forson do anything wrong in even writing the letter? No, he was only performing his official duty. So how do you connect any loss, that is assuming without admitting that there's been a loss, to Ato Forson when he was not the one who made payment or approved the payment? He only asked for an instrument and a letter of credit to be established, which is only a guarantee of a promise of payment based on conditions. So they throw you out, number one. Number two, they say that you claim that the man in writing that letter didn't have authorization. Who has the responsibility to prove that he didn't have authorization? Godfred Dame and the trial judge, Justice Efia Sewa, say that, Samson, if I say you are a thief, and you say you are not a thief, then the onus is on you to prove that you are not a thief. Godfred Dame goes to court and says, Ato Forson didn't have authorization in writing those letters. Ato Forson says, I had authorization. In fact, he had not even opened his defense. But these are things that his lawyers put across during cross-examination of prosecution witnesses. The judge says, because the state says you didn't have authorization, and you claim you had authorization, then come and prove you had authorization.
Remember, the judge also references the statement, caution statement or statement that Setepe had given. Even though the Supreme Court, the Court of Appeal says, at the time Setepe was giving that statement, confirming that ABC had done, he said he needed better information because he needed recollection and things. So the judge didn't just base it on...
She just based it on that.
No.
100%.
She added that.
100%. No,
you can't challenge.
No, because it was rather Ato Forson and his lawyers who were impressing on the judge to consider that caution statement of Setepe. Which caution statement? That is the ground, the sixth ground of appeal, that the judge did not take into account a material evidence that could have inured to the benefit of Ato Forson. Because to Dr. Bassett, that caution statement by Setepe was conclusive, that he was aware of what his deputy Ato Forson did. And the judge said, no, that evidence has not been cross-examined.
That there has been an inference made.
Exactly.
But it does not meet, that inference does not meet the test.
Exactly.
For establishing
if you read that ruling of the judge, she lays out the law in her view, which is that when a party asserts the positive and another asserts the negative, the onus is on the one asserting the negative to adduce evidence. And my lord, Akabuafo and Bright Mensa were very clear that that position is alien to the law. He who alleges must prove, especially in criminal matters. The accused person has no duty, no responsibility to participate or to aid in his own prosecution. So if you claim he had no authorization, prove it. There was no evidence on record, Samson. No evidence. Not even one of the witnesses who were called by the Attorney General testified to the effect that Ato Forson had no authorization. No evidence. And yet the judge says, Ato, come and show that you had authorization. The Court of Appeal says this was travesty of justice. It should not have happened in the first place. Ato Forson had no business even opening his case. What has happened was a complete waste of time.
Thank you.
And that is why they have dismissed the matter. But you see, Samson, you asked Bobby a question, which I totally disagree with, because that is not the view I got reading the judgment. The judges in the majority are not saying that the state can have a case or can have a remedy if they decide to go after the Ministry of Finance or the the officers and the Ministry of Health.
We are making from the judgment.
No.
It's an obvious inference.
Read paragraph
very
150.
obvious.
Read paragraph 150.
What?
Let me tell you.
Which part?
Because when you come down to paragraph 150, my Lord Akabuafo even begins to look at the issue of whether or not there's been a loss. Because you hear him saying that here is the case that the ambulance in question have been supplied you. The ambulance you paid for have been supplied you. You say that there are defects with the ambulances. You have traveled to go and meet the supplier. In line with the provisions of the contract, you have negotiated an amicable settlement, which is that the supplier should ship to you the parts that are missing from the ambulances for the defects to be remedied. Meaning that the parties have agreed that the defects can be remedied. And that agreement has been signed. And the party, in fulfillment of its obligations under that new agreement, if I can call it that, have shipped the parts to you, which got to Ghana as far back as November 2016. Then he references what Ajimamenu, Minister of Health, said in the witness box. You had a duty to clear the parts and notify Big C so that they will come and install the parts in the ambulances and train your officers on the operation of the ambulances. Ajimamenu told the court that they didn't have any money to clear the medical supplies from the ports. So that is why if you read paragraph 150.
Okay, so let me just read that.
Just read paragraph 150. Yes.
Paragraph 150 says that in my respectful opinion, it defies logic that Jakpa at business, agent of the supplier, Big C, would be charged with causing financial loss to the state based on the facts in the record of appeal when the plan put in place to rectify the defects of the ambulances to enable their use has not been implemented because the government failed to meet its obligations under the roadmap agreed to in 2016. In any event, that roadmap leading to the shipment of the parts to Tema Port was agreed upon between the Ministry of Health and Big C, not with Jakpa at business. So it is not clear why Jakpa at business will be asked to go and pay and clear the items to rectify the anomalies on the ambulances. As a corollary to the foregoing, it bears mentioning that if there are vehicles, even if deficient in certain requisite parts, packed in Ghana, an action plan in place between the Ministry of Health and the supplier, Big C, to rectify the deficiencies and the additional parts or accessories in storage at Tema Port for the said rectification, then there is a need to reassess the quantum of the alleged loss, a factor that impacts the case against all the accused in this case, and calling into question the maturation of the charges proffered against the accused person.
Of the charges.
So
you get my point here.
Yeah, so let's be clear.
Okay, it is not the case. I was the one who...
It is not the case that you cannot from this judgment discern that there are proper people who should be charged if there should be a charge. That there are proper people you can take on in a civil matter for a recovery if you desire to do so. It's the quantum.
Not the quantum. Aside the issue, no, he just spoke about the need to reassess the quantum, and then he says it calls into question the maturation of the charges. What is he talking about? Because he is trying to tell you that if you say that somebody has supplied ambulances to you, but the ambulances are deficient,
right,
and you have agreed with the person on the rectification of those deficiencies,
and the person has
supplied you with the things, and you have taken delivery of the things, but you have refused to clear those things, then the question of whether or not you can even charge the person of financial loss is something that we must talk about in the first place.
Yes.
Because for me,
it's okay.
It's because let me just conclude. Because for me,
thank you. Point is made.
No loss was occasioned under this transaction.
Thank you,
until the Kufuor Bawumia NPP government under Ajimamenu. I just want to land. Let me just land.
It's enough.
In 30 seconds. Decided for cheap politics to, leave those medical supplies at the port without clearing them so that they could make a case of willfully causing financial loss to the state against Ato Force.
So here we are again.
So they are the ones who have caused the loss.
So, Sammy, thank you. Here we are again, Ghana, in a situation like the gallopers, right? The famous gallopers. Okay. You suggested one thing.
Yeah.
I need just a minute's reaction, please, and I'll stop you.
All right.
You suggested one thing, that this is a political witch hunt against Ato Forcing because he's a leader of the minority in parliament.
Yeah.
This case was filed on the 23rd of December 2021.
Yeah.
Ato Forcing was not the minority leader.
Yeah. Can I answer you? Number one, if you go and watch what I said, I didn't say because he was the leader. I said one of our lead parliamentarians who was deemed as a stumbling block to government's bad decisions. Even though he was not minority leader, he was a ranking member for finance. And if you recall the time they filed this matter, it was in the heat of the debate over e-levy when the finance committee, our side of the finance committee, took a stand against the e-levy and the 2022 budget. And so he was already in leadership as a ranking member for finance, very vociferous and at the forefront of our struggle against the misgovernance.
Let's take it from there before